Natasha Joly, 60 Orion Road, Berkeley Heights. As you're aware, I am a BOE member, parent taxpayer, and what I'm about to say are my own thoughts and opinions. I'll probably go beyond the 3 minutes, but I hope you could just give me the courtesy to finish. So just piggybacking off the Environmental Commission, recommendations, it's interesting that that came after everything that happened with the lease. So I'd like to talk about Resolution 2025-270, as well as the recent announcement from the Rec Commission about the turf field. On September 2nd, the BOE and the district received an email from Ms. Varnerin that stated, after initial discovery, it is highly probable that the area where the turf field would be installed would be classified as wetlands by the New Jersey DEP. After reviewing all options available, the most cost-effective solution is to replace the existing natural grass with natural grass sod with improved drainage, irrigation, and lights. So leading up to this announcement, let's recap what happened. 5 years of pitching the turf field at Lower Columbia, non-binding resolution for pushing for the lease for the purpose of a turf field, manufactured insurance issue as the excuse to lock out GL students from the tennis courts, threatening emails from the township attorney, forced negotiation in public during a BOE meeting, orchestration of community and PLL writing campaign to the BOE about the immediate need for a turf field, and then passing the lease quickly via resolution rather than ordinance. Yet it's only now that it's been determined that you can't put a turf field there. So some of my concerns about the resolution and Ms. Varnerin's statement. I've asked Ms. Varnerin what constitutes initial discovery. I received no response, so I opened the material. My guess is I'm not sure if there's anything there because, the resolution itself speaks to the work that needs to be done in order to determine what can go onto that field. On March 13th, Mr. Solomon, the township attorney, wrote the board attorney, every day the residents are being harmed by the board's failure to act, and the township will no longer shoulder the blame for that, and it will not shoulder the blame for that any longer. So what exactly has the township done for the last 6 months? Or is it that a signed lease miraculously stopped the harm to the residents? I also find it very telling that after a highly public intimidation campaign to sign this lease, the no turf announcement came so quietly. Ironic, Mrs. Pogue and Ms. Viana bristled that this information was shared with NJ 21st, an online publication, given how much township shared with Tap Into, another online publication, during the pressure campaign. It's problematic that Ms. Varnerin, who also has authority to direct public tax dollars, conducts business without a township email address. How would the public be able to open a township-related business from her personal email account? Finally, the most important concern for me is the improper way the township enacted the lease. On an email chain on this topic, Mr. Solomon made the following statement. While the agreement was initially stylized as a lease, it is, for all intents and purposes, a shared services agreement, which may be authorized by resolution. Really, because I thought the township needed a lease to apply for grants. The agreement that was signed was clearly labeled a lease. The township's resolution called it a lease. NJSA 40A 12-5 clearly states that any municipality by ordinance may provide for the acquisition of any real property, capital improvement, or personal property by purchase, gift, device, lease, exchange, condemnation, or installment purchase agreement. Ordinances require public notice, 2 readings, a hearing, and give residents the right to petition for a referendum. The lease was passed by the township as a resolution, bypassing the requirements of the ordinance, period. Is it compliance with state statutes not, required anymore? So just to wrap it up, the timing of this resolution also is a bit of a red flag for me. There's nothing for months, yet once Ms. Varnerin's update is made public, there's a rush to pay the consultants. So I would ask that the council table resolution 2025-270 until it is clear what's been done, because it's not clear to the BOE or the community to determine that, to determine what's behind the recent statement, and until the lease is passed as an ordinance. Thank you.
Thank you.